I had exactly $10.5 million sitting in a private escrow account, and not a single person in my family knew it existed. My name is Claudia Merritt. I was 37 years old, a logistics and supply chain consultant who had spent 11 years building a mid-sized freight management firm from a spare bedroom in Charlotte, North Carolina. The company was called Meridian Freight Solutions. I started it with a $14,000 personal loan, a second-hand laptop, and a client list of exactly 3 small manufacturers who trusted me more than they trusted the larger firms, quoting them twice the price. By year 4, we had 12 employees. By year 9, we had contracts with regional distributors across 6 southeastern states. By year 11, a private equity group out of Atlanta made me an offer I spent 4 months verifying before I finally said yes. 11 years of 60-hour weeks. 11 years of missed holidays, deferred vacations, and quarterly panic attacks I never told anyone about. And at the end of it, $10.5 million wired cleanly into an escrow account under the name of a holding LLC my attorney had incorporated 14 months earlier, specifically for this transaction. I should have felt invincible the morning that wire cleared. Instead, I was sitting in a rehabilitation facility in South Charlotte, 6 weeks into recovery from a T-bone collision that had fractured my left collarbone, cracked 2 ribs, and left me with a moderate traumatic brain injury that made bright lights feel like needles behind my eyes. A distracted driver had run a red light on a Tuesday afternoon in March while I was heading to a closing dinner with the acquisition team. I never made it to that dinner. My attorney signed the final documents on my behalf with a medical power of attorney I had thankfully executed 2 years prior. So the money arrived while I was lying in a hospital bed, unable to lift my left arm above my shoulder, squinting at paperwork through an ice pack pressed against my temple. My husband, Marcus, sat beside me when we got the confirmation email from the escrow agent. He read it aloud quietly. He did not celebrate loudly. He just closed the laptop, held my hand, and said we needed to talk before we told anyone. I almost dismissed him. My instinct was to call my mother immediately, to call my brother Devlin, to call my sister-in-law Patrice, to let them feel the weight of what 11 years had produced. Marcus said, very quietly, "Give me 48 hours before you do that." He had a reason. And when he told me what it was, I felt something cold move through me that had nothing to do with the hospital air conditioning. Let me take you back to the beginning of what Marcus had been quietly watching for 3 years while I was too deep inside the company to see it clearly. Marcus is a forensic accountant. He has been one for 14 years. He works primarily with estate litigation firms and occasionally consults for a federal oversight contractor. He does not talk about his work at dinner parties. He is the kind of man who notices things and says nothing until he is certain. He had become certain 6 months before the accident. It started with a voicemail. Not a voicemail anyone meant to send. Devlin, my older brother by 4 years, had called Marcus's cell phone by mistake in November of the previous year. He had meant to call his wife Patrice. The call connected, went to voicemail, and Devlin never realized his error. The recording ran for 4 minutes and 19 seconds before he hung up. Marcus listened to it once. Then he saved it to 2 separate encrypted cloud locations and said nothing to me. Not because he wanted to keep a secret. Because he wanted to be certain before he handed me something that could not be unheard. In that voicemail, Devlin's voice was relaxed. Casual. The way people sound when they believe they are completely alone. He was talking to Patrice about a conversation he had apparently already had with our mother, a woman named Gloria Merritt, retired schoolteacher, 64 years old, and the person I had considered my closest emotional anchor for my entire adult life. The substance of that conversation, as Devlin described it in the voicemail, was this. Once Meridian Freight Solutions sold, and they all believed it would sell within the year, they needed to move quickly. Gloria had apparently already spoken to a local attorney about whether Claudia's existing verbal commitments to help with the family constituted a legally enforceable promise. The attorney had told her no. So they were considering a different approach. Devlin described it in 3 sentences that Marcus would later have formally transcribed by a legal stenographer. He said, and I am paraphrasing only slightly, that if Claudia came out of the sale with 8 figures, and if they positioned themselves correctly before she had time to set up proper estate structures, they could reasonably expect to access a significant portion of it through a combination of family pressure, strategic loan requests that would never be repaid, and, if necessary, a challenge to any trust or will structure she established on the grounds of undue influence. Undue influence. That is a legal term. It means convincing a court that someone was psychologically manipulated into making financial decisions that did not reflect their true wishes. They were going to wait until I was emotionally vulnerable, surround me with manufactured warmth, extract as much as they could through informal means, and then, if I ever tried to legally protect my assets, contest those protections by arguing I had been pressured into them by Marcus. Marcus, my husband. The man they had apparently already begun privately describing to our extended family as controlling and financially isolating. Marcus did not tell me any of this until 6 weeks after the accident, when the escrow had cleared, when my neurologist had confirmed my cognitive function was fully restored, and when he had spent those 6 weeks quietly and methodically building a file. I want to be precise about how I felt when he sat down across from me in that rehabilitation room, placed a manila folder on the rolling tray table, and began walking me through what he had found. I did not cry. I did not raise my voice. Something happened in my chest that felt less like heartbreak and more like a slow, irreversible calcification, like something soft turning permanently hard. I looked at the folder. I looked at Marcus. And I said, "Show me everything." The voicemail was the beginning, but it was not the worst of it. Not even close. What Marcus had built over 6 weeks, using tools available to any licensed forensic accountant with the right institutional access and a great deal of patience, was a documented timeline of financial extraction that went back 4.5 years. It began with my mother. Gloria had been on my personal American Express account as an authorized user since I added her 7 years ago, when her car needed emergency transmission work and I wanted her to have access in case of medical emergencies. She understood the card was for emergencies. She had signed a written acknowledgement of that understanding, which I had kept in a file without ever expecting to need it. Marcus pulled the last 4 years of statements and created a categorized ledger. The emergency medical column was nearly empty. The leisure column was extensive. 11 flights, 9 hotel stays at resort properties, 42 restaurant charges at venues that did not accept coupons, 17 charges at clothing retailers, for charges at a jewelry store in Myrtle Beach I had never heard of. Total, across 4 years, $91,400. Then there was Devlin. 3 years ago, Devlin had approached me during a family Christmas gathering with what he described as a time-sensitive business opportunity. He was launching a small commercial cleaning company and needed startup capital to purchase industrial equipment. He showed me a quote from a supply vendor. He showed me a draft LLC filing. He told me he had already secured 2 anchor clients, a medical office complex and a school district maintenance contract. He asked for $65,000. He said he would begin repaying it in quarterly installments starting 8 months after launch, once cash flow stabilized. I wrote the check. Marcus pulled Devlin's business registration records from the North Carolina Secretary of State database. The LLC was filed. It remained active on paper, but the 2 anchor clients Devlin had described did not exist. The medical office complex had no record of any cleaning contract with Devlin's company. The school district had no record of any vendor relationship with that LLC. Marcus submitted public records requests to both institutions and received written confirmation of no such contracts within 3 weeks. The $65,000 had gone into Devlin's personal checking account. From there it had moved in 3 transfers. One to pay off a credit card balance. One to Patrice's personal savings account. One to a down payment on a boat registered in Devlin's name in Mecklenburg County. I had a signed promissory note from Devlin for that loan. He had never made a single payment against it. And then there was the piece Marcus discovered in week 5, the piece that transformed what I had been thinking of as a family betrayal into something that required immediate legal intervention. My father, Raymond Merritt, had passed away 6 years ago. He left behind a modest estate, the family home in Concord, a small investment account, and a will that divided his assets equally between myself and Devlin, with Gloria receiving lifetime use of the family home. The estate had been administered by a local attorney named Harold Sims, who had since retired. Marcus contacted Harold Sims through his former firm to request copies of the estate closing documents. Harold Sims responded promptly. He was cooperative and apparently unbothered by the inquiry because he believed everything had been handled correctly at the time. It had not been. The investment account my father left behind had been valued at the time of probate at $43,000. It had been liquidated and split evenly between me and Devlin, $21,500 each, according to the closing documents I had received and signed without question 6 years ago. But the account statements Marcus obtained from the brokerage through a formal records request told a different story. At the time of my father's death, the account held $103,000, not $43,000. $60,000 had been withdrawn from that account in the 4 months between my father's death and the initiation of probate proceedings. The withdrawals had been made using a transfer on death designation that had been quietly added to the account 11 months before my father died, designating Devlin as sole beneficiary of any pre-probate withdrawals. My father had moderate dementia in the last 2 years of his life. He had been in Devlin's primary care during those years because I was building the company and Devlin had presented himself as the responsible sibling stepping up. Devlin had power of attorney over my father's finances during that period. The transfer on death designation had been added during that window. Marcus placed that document on the tray table last. He did not say anything dramatic. He just let me read it. I read it twice. I put it face down on the blanket. I looked out the window at the parking lot below. Then I said, "Get me Rebecca Holt's number." Rebecca Holt was an attorney I had met twice at industry events. She specialized in civil fraud litigation and estate recovery. I had never needed her before. I had her card in my phone contacts because Marcus had put it there 2 years ago, without explanation, and I had never asked why. I understand now why he did that. I called Rebecca from the rehabilitation facility that afternoon. She answered on the second ring. I told her I needed an urgent consultation. She said she could be there by 4 o'clock. She arrived at 3:58 carrying a leather portfolio and a recorder, which she placed on the table and asked permission to use. I said yes. Marcus sat beside me. We walked her through everything in order, starting with the voicemail and ending with the estate withdrawal. Rebecca listened without interrupting. When we finished, she was quiet for approximately 15 seconds. Then she said, "The estate issue is the most actionable. The promissory note default is straightforward civil recovery. The credit card misuse depends on the written acknowledgement you mentioned. And the voicemail is evidentiary gold if authenticated properly." She paused. Then she said, "Before we file anything, I want to talk to you about a strategy. Because right now, they don't know what you know. And that asymmetry is an asset." She leaned forward and said something I have thought about almost every day since. If they believe you are financially desperate, they will keep talking. And every word they say from this point forward is evidence. Marcus looked at me. I looked at Rebecca. "What do you need from us?" I asked. Rebecca needed 3 things. She needed the voicemail formally authenticated and transcribed. She needed Marcus to prepare a forensic summary of all financial extractions in a format suitable for court submission. And she needed me to do something that made my stomach tighten when she described it. She needed me to call my family and tell them the sale had fallen through. Not that I was bankrupt. Not that I was broke. Just that the acquisition had collapsed at the last moment due to a financing contingency on the buyer's side, that I was back to running the company at a loss, that the accident had left me with mounting medical debt, and that I was genuinely frightened about my financial future. Rebecca explained the strategy with the precision of someone who had done this before. If my family believed I had no money, they would stop performing. They would stop calculating. They would reveal exactly how they felt about me when my bank account offered them nothing. That behavioral evidence, documented and time-stamped, would be relevant to the undue influence claim they had been planning to use against me. It would demonstrate that their relationship with me was conditional and financially motivated, which would neutralize any future argument that Marcus had isolated me from a loving family. It was, in legal terms, a fraud carve-out provision playing out in real time. Any claim they might later make about family bonds and natural affection would be undermined by documented evidence of abandonment the moment those bonds stopped paying dividends. Rebecca also explained one more thing. The LLC structure Marcus had set up for the acquisition, the holding company through which the $10.5 million had been received, contained a clause inserted by Marcus and quietly approved by our transaction attorney 14 months ago. A canary clause. It was buried in the operating agreement, and it did one specific thing. If any third party initiated a legal challenge to the ownership or distribution decisions of that LLC, claiming undue influence or coercion, the clause automatically triggered a restructuring that moved all liquid assets into an irrevocable trust with a 5-year distribution lock. Devlin and Gloria's plan to challenge my estate structures would not open a door. It would permanently seal one. They had been building a trap, and they had built it around a box that was already locked from the inside. I put the phone down on the blanket beside me. I stared at the ceiling for a long moment. Then I picked it up and called my mother. The conversation with Gloria lasted 11 minutes. I kept my voice measured, tired. I told her the acquisition had collapsed. I told her the buyer's financing had fallen apart in the final week. I told her I was still recovering from the accident, that the medical bills were significant, and that I was genuinely uncertain about what came next. There was a pause on her end. A pause I recognized not as maternal concern, but as recalibration. She said she was sorry to hear that. She said she hoped I would recover quickly. She did not ask about Marcus. She did not ask what she could do. She said she would pray for me, and that she hoped things would turn around. She got off the phone in under 4 minutes. I called Devlin next. His response was faster and more telling. He did not pause at all. He said that was a shame and that he had told me a year ago that private equity deals were unreliable. He said he hoped I had not overextended myself on the assumption of the sale proceeds. He said Patrice sent her love. He was off the phone in 3 minutes. Marcus was watching me from across the room. He did not say anything. I just nodded once, and he nodded back. Over the next 3 weeks, I documented everything. Every unanswered text. Every call that went to voicemail. Every family group chat message that I could see was read but not responded to. Rebecca had advised me to send 2 specific communications during this window, both through text, both carefully worded, both designed to create a paper trail of the moment I reached out and the moment they chose silence. The first was a message to Gloria asking if she could help cover 1 month of my physical therapy copays while I stabilized. $200. The amount was specific and deliberately small. She read the message. She did not respond for 6 days. When she finally did, she said she was on a fixed income and could not help right now. The second was a message to Devlin asking if there was any possibility of beginning repayment on the promissory note, even partial, given my current circumstances. He read it immediately. He did not respond for 9 days. When he did, he said the business was going through a slow period and he would reach out when things improved. Rebecca had both responses printed and added to the evidentiary file. At the same time, Marcus was completing the forensic summary. It was 41 pages. It included account statements, wire transfer records, brokerage documents, Secretary of State filings, public records responses, a formal transcription of the voicemail with a metadata authentication report generated by a digital forensics consultant Rebecca retained, and a photographic exhibit of the boat registered in Devlin's name 3 weeks after he received the $65,000 I believed was funding a legitimate business. The metadata authentication was the piece I want to explain carefully because it mattered enormously later. When Devlin eventually claimed the voicemail had been fabricated or edited, Rebecca was prepared for that. The digital forensics consultant had extracted the creation timestamp, the device identifier, the carrier transmission data, and the audio waveform profile from the original recording. These elements, taken together, confirmed that the recording was continuous, unedited, and generated by Devlin's specific device on the specific date in November at the specific time Marcus received it. The authentication report was 30 pages on its own. You cannot argue with metadata. Devlin learned that. Rebecca filed the civil complaint on a Thursday morning, for weeks after my discharge from the rehabilitation facility. The complaint named Devlin Merritt and Gloria Merritt as defendants. The causes of action were breach of promissory note, conversion of estate assets, unauthorized use of credit, and civil fraud. She simultaneously filed for a prejudgment asset freeze on Devlin's known accounts and the boat, arguing that without the freeze he would dissipate assets before judgment. The judge granted the temporary asset freeze the same afternoon. Devlin's personal checking account, the boat, and a joint savings account he held with Patrice were frozen pending the outcome of the litigation. Rebecca also sent a formal demand letter to Gloria requiring the return of $91,400 in unauthorized credit charges within 30 days or face inclusion in the civil complaint. Neither of them knew any of this was coming. Neither of them had any warning. And neither of them knew that in 4 days, they would be sitting in the same room as me, in front of an audience of 200 people at the Carolina Business Excellence Awards ceremony, where Meridian Freight Solutions had been nominated for Regional Growth Company of the Year. The nomination had been submitted 8 months earlier, before the sale, when the company was still mine on paper. The organizing committee had not yet updated their records to reflect the acquisition. My name was still on the nomination, and because I had quietly called the committee chair 3 weeks earlier to explain the transition and ask whether I might still be recognized as the founding principal, she had graciously agreed. What neither Devlin nor Gloria knew was that I had not told them the sale had failed to protect my feelings. I had told them that to watch what they did next. And what I did not tell Rebecca until 2 days before the ceremony was that both Devlin and Gloria had received invitations to the awards event. Meridian had always nominated 2 family guests per year for the gala dinner. Their invitations had been sent 8 months ago when the nomination was submitted. Neither of them had declined. Devlin had RSVP'd yes for himself and Patrice. Gloria had RSVP'd yes with a +1. They were coming to celebrate a company they had tried to financially dismantle its founder. I wore a dark green dress. Marcus wore a charcoal suit. We arrived early and sat at the front table reserved for nominees. I want to tell you about the man sitting at the table directly adjacent to ours, because this is the part of the evening that I could not have engineered if I had tried. His name was Warren Clegg. He was 71 years old, a retired appellate judge who now served on the board of the Charlotte Business Foundation, one of the primary donors funding the awards program. He had presided over civil fraud cases for 19 years before retirement. Rebecca knew him professionally. She had not orchestrated his presence at the table next to mine. He simply attended every year because he sat on the foundation board. He was there, and he would matter. Devlin and Patrice arrived at 20 minutes past 6. Gloria arrived with her neighbor, a woman named Connie who had known our family for 30 years. They were shown to their table, 2 rows back from the front. I watched them in my peripheral vision without turning my head. They had dressed for a celebration. Patrice was wearing a cocktail dress I recognized from a designer boutique charge on the credit card statement in Marcus's forensic file. Devlin was in a suit that still had the subtle crease of something recently dry cleaned for a special occasion. They did not immediately see me at the front table. The room was full and the lighting was directed at the stage. The program began at 7. The MC worked through 3 award categories before reaching Regional Growth Company of the Year. When the presenter read the name Meridian Freight Solutions and invited the founding principal to the stage, I stood from the front table, smoothed my dress, and walked to the podium. I heard the moment they saw me. Not a sound. An absence of sound. A specific silence from 2 rows back that I felt in the back of my neck. I accepted the award. I thanked the committee. I gave a 90-second acknowledgement of the team that had built Meridian across 11 years, and I mentioned Marcus by name, describing him as the financial architect who had protected the company's integrity from its earliest days. I did not look at Devlin's table. I walked back to my seat. 30 seconds later, I felt a presence behind my left shoulder. I turned slightly. Devlin was crouched beside my chair, speaking very quietly, his jaw tight, his eyes doing the calculation in real time. "The sale went through," he said. It was not a question. "It did," I said. "When?" "About a month before you told me the business was going through a slow period," I said, "and that you'd reach out when things improved." He straightened up. He looked at Marcus. Marcus looked back at him with the expression of a man who has already filed 41 pages of documentation and is simply waiting for the legal calendar. Devlin returned to his table. I watched him lean across to Patrice and say something I could not hear. Patrice's face went very still. Gloria had been watching from 2 rows back. When our eyes met across the room, she looked away first. What happened in the following weeks unfolded not in a ballroom, but in a courtroom on East Trade Street, and in a series of depositions conducted in a conference room on the 14th floor of Rebecca's firm. Devlin hired an attorney. His attorney's first motion was a challenge to the authenticity of the voicemail recording. Rebecca filed the digital forensics authentication report in response. The motion was denied. His attorney's second motion argued that the promissory note was unenforceable because it lacked specific repayment terms. Rebecca produced the signed document, which contained a repayment schedule with quarterly dates beginning 8 months after loan origination. The motion was denied. His attorney's third and final significant motion attempted to argue that the estate withdrawal had been authorized by my father under a valid power of attorney. Rebecca produced the medical records documenting the progression of my father's dementia during the relevant period, alongside a forensic document examiner's report concluding that the transfer on death designation had been completed under conditions inconsistent with informed financial consent. The judge reviewing the case made a referral to the Mecklenburg County District Attorney's Office regarding the estate withdrawal. That referral was the moment the asset freeze became permanent. I want to tell you about Warren Clegg, the retired appellate judge who had been sitting at the table next to mine at the awards ceremony. He had recognized Rebecca from across the room that evening. He had asked her, briefly, how her practice was going. She had mentioned the case without naming parties. He had asked one question, which was whether the digital authentication had been conducted by a qualified forensic examiner. She said yes. He said good and returned to his salad. But 3 weeks after the ceremony, Warren Clegg submitted a letter to the court as a character reference, not for me, but for the evidentiary standards Rebecca had applied in building the case. He had reviewed the authentication methodology on his own initiative and found it consistent with standards he had applied in federal appellate review. His letter was 2 paragraphs. It carried weight that Rebecca said she could not have purchased. She had not asked him for it. He had simply done it because he believed in procedural integrity. That was the ally I never knew I had. The civil judgment came down 14 months after the initial filing. Devlin was ordered to repay the $65,000 principal of the promissory note plus interest and legal fees, totaling $81,200. The estate recovery claim resulted in a separate order requiring Devlin to return $60,000 to the estate, which was then properly distributed with my correct share going directly to a charitable foundation I had established in my father's name. Gloria settled the credit card claim out of court for $74,000, which she paid in installments drawn from the equity in the family home. The canary clause in the LLC operating agreement was never triggered because Devlin's attorney advised him clearly that any challenge to the trust or holding structure would accelerate consequences he was not positioned to absorb. The clause sat there quietly the entire time. It never had to activate. It simply had to exist. The disinherit clause was a separate matter. I had executed a new estate plan with Rebecca's referral attorney 2 weeks after filing the civil complaint. My revised will and trust documents contained explicit language memorializing the documented financial conduct of both Devlin and Gloria and excluding them from any inheritance consideration. The clause was notarized, witnessed, and filed with my estate file. It was not punitive. It was documentary. It said, in legally binding language, that the exclusion was based on specific and substantiated conduct, not emotion. That distinction mattered to me. 1 year later, I was sitting on the back porch of a house Marcus, and I had purchased on Lake Norman, 30 minutes north of Charlotte. It was a Sunday morning in April. The water was still. I had a cup of coffee and a book I had not gotten very far into because I kept stopping to look at the water. Marcus came out and sat beside me. He did not say anything for a while. Then he said, "How are you feeling today?" I thought about it honestly, which is something I try to do now. "Lighter," I said. "Still a little sad, but mostly lighter. The sadness is real, and I will not minimize it for the sake of a cleaner ending. These were my mother and my brother. I spent decades loving them in good faith. The grief of that specific loss, the loss of people who are still alive, but who revealed themselves to be something other than what I believed, that grief does not resolve cleanly. It settles. It becomes something you carry differently over time. But what I do not carry anymore is the weight of financial obligation to people who treated my success as a resource to be harvested. That weight is gone. And its absence is something I feel every single morning. Devlin completed his repayment schedule on time because the alternative was contempt of court. He and Patrice sold the boat to help cover the judgment. Gloria's installment payments cleared reliably because Rebecca had secured a lien on the family home as collateral for the settlement. I do not know what they say about me at family gatherings now. I do not attend them. I send a card to my mother on her birthday because she is 64 years old and she raised me before she decided my bank account was more valuable than my trust. The card contains no money. It contains no return address. It simply says I hope you are well. I mean it. I genuinely do. Sarah, my physical therapist during recovery, became a friend I still have lunch with on the second Thursday of every month. She never knew the full scope of what was happening during those weeks of rehabilitation. She just showed up consistently, professionally, and without agenda. That consistency was something I was, at that time, learning to recognize as rare. Marcus still works in forensic accounting. He has never once said, "I told you so." Not once. Rebecca Holt sent me a handwritten note after the judgment came down. It said, simply, that it had been an honor to work on a case built with that level of evidentiary care. I framed it. It is hanging in the hallway of the lake house. Here is what I want to leave you with, because I believe this story is about something larger than one family's particular collapse. Financial success makes you visible. And visibility, in families where money has always been scarce and resentment has quietly accumulated, can transform relationships in ways that are difficult to see from the inside. The people who love you before the money usually love you after it. The people who begin to see you differently once success arrives, who become more interested, more attentive, more present, those changes deserve examination. Not suspicion. Examination. The hardest part of what I did was not the legal process. It was choosing to see clearly when everything in me wanted to explain it away. Wanted to find a version of events where my mother was just scared and my brother was just struggling and everything I had documented could be understood as something other than what it was. I am not naturally a suspicious person. That is a flaw that nearly cost me everything. But I had a partner who noticed. And I had the discipline, once I knew, to be still, to gather, to document, and to act through legitimate systems rather than through emotion. Revenge is not a feeling. It is a structure. It is the careful construction of consequence through truth. The $10.5 million is in a trust. It is invested conservatively. It earns what it earns. I do not think about it every day, which surprised me. What I think about every day is the lake in the morning. Marcus's coffee, the book I keep meaning to finish. And sometimes, very quietly, I think about my father, about how he worked 30 years to leave something behind for his children, about how that money was supposed to be split equally between us. I made sure his name went on something real, a foundation that funds college scholarships for first-generation students in Cabarrus County, where he was born and where he taught himself to read at the kitchen table of a house with no indoor heating. He would have liked that. If you have ever found yourself carrying the financial weight of people who treat your success as something they are owed, I want you to hear this clearly. Generosity is a virtue. But generosity without discernment is not kindness. It is an invitation. Know who you are giving to. Document what you give. And if the people around you only appear when your accounts are full, that is information. That is the most important information you will ever have about those relationships. What would you do if you suddenly came into a life-changing sum of money and you were not sure who around you actually loved you versus what you represented? Would you test it? Would you trust? Would you wait and watch? Leave your answer below. And if this story stayed with you, subscribe, because the next one is already waiting for you.